Hello, I'm Cara Swift. I'm an associate who's qualified for 5 years, and I specialise in all areas of family law, including financial issues following divorce and dissolution of a civil partnership, children issues, including children arrangements and schooling issues, international relocation claims, pre- and post-nuptial agreements, and I have a particular focus on the claims that unmarried couples can bring. Unfortunately, there's still a misconception that there's such a thing as common law marriage. Those in enduring relationships or who live as husband and wife, as they think, believe that there might be claims that are akin to those that married couples have, which is unfortunately just not the case. And I have recently prepared a response to a call for evidence by the Women and Equalities Committee, who are conducting a review into the rights of cohabiting couples. So it is on Parliament's agenda, but it has been for some time. And for now, cohabiting couples need to think really carefully about the way in which they arrange their finances and children matters following the breakdown of their relationship. Broadly speaking, the financial claims that can be brought following the breakdown of a relationship where the couple isn't married are very limited. They generally fall into two categories, and they are the rights of property and property ownership, and then claims that can be brought on behalf of a child. The latter is brought under Schedule 1 and include claims such as the settlement of a property for a child or lump sums for expenses for the benefit of a child. Depending on the income of the paying parent, if it's over £156,000 gross per annum, then that can also be child maintenance and top-up provision akin to a carer's allowance. If the paying parent is under that threshold, then the obligation to pay child maintenance is covered by the child maintenance service if you can't come to an agreement. The former, being the claims in relation to property rights and property ownership, is governed by the Trust of Land and Appointment of Trustees Act, and where you're a legal owner of a property, either jointly or tenants in common with someone else, you can make an application to force an order for sale of the property, or you're able to bring an application for a declaration of an interest in that property. The easiest way, the starting point, is probably to think of the property as an analogy of an orange. So you have the skin, which is the legal ownership, and the bit in the middle, the juicy orange, is the beneficial interest. And the two don't necessarily have to be with the same person. It's possible to bring an application for a beneficial interest in the property arising from a financial contribution, a promise, an agreement, and that you have relied on that to your detriment. The applications are brought in the strict civil court as opposed to the family courts, and so they are complicated, they can be lengthy, and there are cost consequences that need to be seriously considered. It's important from the outset of considering within your relationship that you might be purchasing a property to set out the clarity of how you wish to hold it, and have that same discussion with your conveyancing solicitor, who'll be able to explain the difference between being joint tenants and tenants in common, whether that be equal tenants in common or in unequal shares. Make sure to discuss the Form TR1 with your conveyancing solicitor. This will be the form on which you tick the box as to how you intend to hold the property, and can be the starting point for the evidence of the legal ownership. Further to that, there are deeds of trust that you can enter into that explain the proportions in which you hold and can deal with some more specific and nuanced issues like the increase in a property value and how you deal with that between you. If you're not going to own the property together and it's only going to be registered in one of your names, it's important to have a serious conversation about a cohabitation agreement. They can set out your respective contributions to the monthly outgoings, how you manage the property, and set out your agreement and record that by making those contributions, you do not gain any interest in the property. I was involved in a reported case of Dobson and Griffey in which we successfully defended an application that was brought for a beneficial interest in a property. There was a farm set up with a livery, and Ms. Dobson had renovated the property and carried out work to both the livery and the farmhouse, and it was determined that she had no beneficial interest in the same.